Hi everyone, welcome to our Tech Speak series, where we discuss all things technology. I'm Ian McGinley, a partner in Akin's White Collar Group.
And I'm Mike Asaro, and I'm also a partner in Akin Gump's White Collar Group.
Recently, the United States Attorney's Office for the Southern District of New York charged the first ever digital asset insider trading case. In this video, we'll take a look at that case, the facts of it, the legal theory that SDNY used, and offer some takeaways. First, some background on the case, United States v. Chastain. The indictment alleges that the defendant, who was an employee at OpenSea, which is an online marketplace for buying and selling NFTs, committed insider trading. Now, on OpenSea's marketplace, they would feature particular NFTs for users to purchase. The indictment alleges that as part of Chastain's job at OpenSea, he would select the particular NFTs that would be featured on the homepage. Now, the information about which NFTs would be featured was confidential business information, the indictment alleges. And OpenSea had policies that this information was to be kept confidential, and the indictment alleges that the defendant signed these policies, acknowledging his obligation to keep the information confidential and not use it for his own personal profit. So the claim in the indictment is that before these NFTs were featured on OpenSea's homepage, the defendant secretly bought the NFTs and then sold them once these NFTs were featured on the homepage for a substantial profit. Because once these NFTs are featured on a homepage, their value increases substantially. The indictment alleges the defendant did this for 45 different NFTs and on 11 different occasions. And that he hid his conduct by using a secret OpenSea account that was not in his name, and by using anonymous cryptocurrency wallets to hide the fact that he was purchasing and selling these NFTs.
So let's chat for a minute about what the government charged in this case. So the lead charge was wire fraud. And people may wonder hearing that, well, what's wire fraud and why isn't it securities fraud? Because when you're thinking about insider trading, virtually all of the cases involve people who are buying or selling stocks based on material non-public information. And of course, an NFT is not clearly a security. So there's basically two reasons. One, it's actually not that uncommon for the government to charge wire fraud as an alternative theory of prosecution in insider trading cases. This goes all the way back to the 1980s when the government charged a Wall Street Journal reporter with trading on inside information about companies that would be featured on a column called Heard on the Street, which would, when those articles were released, often cause the securities or the stock prices of these companies to go up. And this was a case called Carpenter versus US. The government in that case charged securities fraud, but as a backup, they also charged mail and wire fraud. And the Supreme Court held that you could also have insider trading under the wire fraud statute, under the theory that basically if you, or in this case, the reporter, misappropriated the confidential information of the Wall Street Journal. So the Wall Street Journal had policies saying that you had to keep this Heard on the Street information confidential, and the reporter basically took that information, he used it to tip off his broker so the broker could trade the stocks in advance of the articles and make money, and that amounted to a theft of property, even though it was intangible property. And this is exactly what the government has charged in the Chastain case, that the defendant in that case, in violation of the confidentiality agreement he signed, misappropriated valuable confidential information about what NFTs were going to be featured on the site and was able to trade those assets ahead of that information. The second reason why the Southern District used the wire fraud statute, in my view at least, is to avoid the thorny question as to whether and when a digital asset can be viewed as a security. And that is the subject of some very active ongoing litigation right now with agencies like the SEC, and courts are currently working their way through the issue as to whether these types of instruments can be, and under what circumstances they can be, securities. But by charging the wire fraud statute in this particular case, the government was able to sidestep that entire issue. Because for securities fraud, you need insider trading in connection with a purchase or sale of a security. But for the wire fraud statute, all you need is for the scheme to involve a wire, which could be an email or a telephone call. And it doesn't really matter what the asset is. And so that's the other, I think, reason why the government took this tact.
So what are some takeaways from the Chastain case? There are a number of them. First is that the wire fraud statute is broad. As Judge Rakoff, an esteemed SDNY judge, once said, the statute is a prosecutor's true love and a Louisville slugger in a prosecutor's toolkit. And you can see why here. The statute covers a wide range of criminal activity. And the theory, as Mike mentioned here, is a misappropriation theory. Essentially, that the defendant embezzled or stole confidential information from his employer and used it to trade for his own personal benefit in instruments other than securities. That's not an unprecedented theory under the wire fraud statute, and we've seen the DOJ use it previously in an insider trading case involving futures contracts before that conduct was explicitly prohibited under the Commodities Exchange Act, and more recently, insider trading based on foreign currency transactions, where the instruments were also not securities. So the theory applied here has actually been used many times. What's different is that this is the first time it's been applied to digital assets.
So I think that really begs the question, what's next? I think there's a couple of things that you can take away from the Chastain case. First of all, I think it's a clear shot across the bow by the Department of Justice towards the digital asset marketplace. This is a marketplace that's been rapidly developing. It really fits a broader theme where the government's been looking to impose more regulation, particularly the Southern District of New York, and has been looking to flex its muscles in this space. It's also, I think, no accident that this case comes on the heels of multiple media reports alleging conduct that approximates insider trading in the NFT markets and also in the cryptocurrency token marketplace. And I think it's a good sign that there's more to come and that the government's going to be looking for more cases where they could use the wire fraud statute to impose an insider trading regime in these relatively new marketplaces. I also think it's a reminder that the government has these tools and could double back and also apply insider trading type concepts using the wire fraud statute in long-standing markets where the participants have really operated on the assumption that they're not dealing with securities. And some good examples are bank debt and also trade claims. And these are markets where generally the view is these are not securities, and particularly in the bank debt market, there are a set of market conventions where people have a certain way of trading that's premised in part on the assumption that you're not really dealing with securities, so the full kind of panoply of insider trading rules don't apply. And I think if the government were to find in these markets or markets like them a case with a bad enough set of facts, they could use the wire fraud statute in spaces like that as well. Now, keep in mind, the wire fraud statute is a criminal statute, so there's a high burden of proof, a higher standard of proving fraudulent intent. So I wouldn't expect the government to just go into markets like this where there's a set of accepted conventions and using the wire fraud statute to completely upset the apple cart with those conventions. But you could have situations in markets like that where people feel like no rules apply and where people go outside what's acceptable market conventions and could be doing things that could be viewed as really egregiously misappropriating confidential information for trading purposes. And I think if the government finds those set of facts in a marketplace like that, you could see a Chastain case in these more well-established markets as well. So that covers the potential implications for other markets, even beyond the digital asset space. Ian, any other takeaways from this case?
Thanks, Mike. The final takeaway, I think, is for NFT and crypto exchanges. The indictment notes that OpenSea had specific policies about maintaining the confidentiality of its business information, including which NFTs were featured on its homepage, and that the defendant had to sign a written agreement acknowledging these obligations. That's good practice, and other exchanges should adopt similar policies covering the use of their confidential business information, and as well as training on what constitutes non-public information, especially in light of the Chastain indictment. Such training and policies will be helpful in mitigating risks from DOJ and SEC inquiries, as well as from class action lawsuits, which we've seen recently, against exchanges for failing to prevent insider trading.
So that's what we were hoping to cover today. Ian, thank you for the very interesting discussion. I hope everybody out there who's watched this has found it valuable.